I left a 7-year relationship. We had 2 amazing children. They were 4 and 1 at the time. It was no longer safe for me to stay. I left my ex-husband because I was being emotionally abused, financially abused, physically abused, and sexually abused. I was exhausted. I could not continue. I found the courage somewhere. I believe it was an extra strength that I had as a mother. My children did not need to continue to witness this abuse. I wanted my children to grow into men and not animals. I left. He was charged with assault and threatening behaviour. The sheriff in the criminal court, after finding my ex-husband guilty, applauded me for being so brave and so strong. The social work, police and Women's Aid all told me that I should be proud of myself for breaking the circle of domestic abuse. And we were free. We were free until 2 months later when we were taken to family court.
Hi there, I'm Faye and I'm a children's worker at Glasgow Women's Aid. Court ordered contact is a situation facing many of the families that myself and my colleagues support. There's been some much needed and welcome developments in Scotland in relation to legislation for children affected by domestic abuse, more of which we'll hear about today. It's also true to say that there's been a lot of organisations fighting for change for some time, supported by members of the Scottish Government and by important advocates for the rights of children, such as Bruce Adamson, who we heard from earlier. However, all of that said, we felt it was important to continue to highlight and spotlight the present realities of the situation for women and children, and note the fact that the new Children's Bill will still take some time to embed, with parts of it also requiring secondary legislation before coming into effect. There is still going to be a lengthy period of time before we can expect to see changes in the courtroom for women and children who are at risk. We also raise some issues that highlight that there is more change needed than simply just legislation change. The situation is grave and the family court system is still so biased against women and children that as frontline workers, seeing this every day, we felt compelled to continue to speak out on the issue. Generally speaking, it's likely that most members of society would hold the view that a mother who has managed to get out of an abusive relationship has done the right thing to protect both herself and her child. However, what most don't realise is that the system the woman must then navigate is contradictory at all turns. The 3-planet model by Marianne Hester highlights the distinct, uncoordinated approaches from different sectors that the women may encounter due to their varying histories, culture and legislation. In Planet A, there is a gendered analysis of the perpetrator with some measures of safety and support mainly for the women. Enter Planet B, and the focus is on the safety and protection of the child, with the woman being told by professionals that she is failing to protect her child from the abuser if she doesn't leave. Picture the woman having had support to leave, and finally she and her child are safe. This changes should they enter Planet C, the family court system. The domestic abuse and potential harm to the child is minimised, and women are expected to facilitate contact at all costs, in spite of any concerns she may have, the views of her child, and even concerns from other agencies.
I was told my ex may not have been the best husband, but he was an excellent father. Not only was I trying to recover from my abuse and start a fresh life with my children, I was now being tortured by his solicitor and torn apart by her. All of the reasons why I stayed in a toxic and highly abusive relationship came back to reality. He was now able to control me through his solicitor and the family courts. This time he was not using his insults and his fists behind closed doors, but he was standing tall in a courtroom, head held high, whilst his solicitor spoke his lies. He has more money than me and more anger. Family court has become his playground. Over the last 4 years, my children have been strong and brave. They have spoken to social work, GPs, police. They have spoken about being scared and spoken about being assaulted. His solicitor has torn my children's words apart, She has pulled the wool over the sheriff's eyes, and she has left my children down.
The woman now finds herself in a situation where her experiences are diminished and the safety of her child is compromised, the very thing she's tried so hard to avoid. The outcome for the woman and her child in Circle C is sadly an all too common occurrence for women and children in our services. Thankfully, in response to years of campaigning, Scotland has recently passed welcome new legislation that seeks to improve the protection of children in the family courts who have experienced domestic abuse. It's important to highlight, however, that there is already an extensive existing framework in place for family courts. Section 11 of the Children Scotland Act sets out that the court shall have regard for the need to protect the child from abuse or risk of abuse, and that the court should consider the ability of the person who has carried out abuse which might affect the child, and also that consideration should be made to the effect of that abuse on the adult with the main parental responsibilities, namely the mother in our cases, and with domestic abuse being specifically mentioned. Furthermore, best practice national guidance for child protection sets out that child abuse assessments by professionals should consider whether abuse has occurred or is likely to occur, and clarifies that abuse need not have taken place. It is only sufficient for a risk assessment to have identified a likelihood or risk of harm. Sadly, despite this existing legislation and guidance that relates to the rights and protection of children, the reality is that when it comes to decisions around contact, family courts still often choose to prioritise the parental rights of the perpetrator. We frequently hear that sheriff decisions are in no way reflective of the views that have been expressed by the child in question, which is so disheartening and concerning, given that the case is about that child and their best interests. It's also not uncommon for decision-making to disregard concerns raised from agencies that specialise in supporting children, such as reports that our organisation may submit, or agencies such as social work. The sheriff may also even choose to disregard the recommendation of court-appointed officials tasked with investigating the case.
My child's paternal grandmother took me to court to see my son. I was concerned about her using the contact to talk about his dad and to find out where we live. We had to move because of the domestic abuse and risk of violence from my ex-husband. A child welfare reporter met with me, my son, his grandparent and some other connected people. They listened to everyone's views and then came to a recommendation. They advised the court that only indirect contact should happen, for example, by a letter. This was such a relief. It meant my son could slowly be reintroduced to a relationship with his grandparent over time, in a way that was safe for us too. However, the sheriff disregarded the report recommendation and instead ordered 2 hours of contact at a local park every weekend. We feel it's only a matter of time before his dad will follow us home now that he knows where we will be. My son has started to have nightmares and speaks of butterflies on his tummy on the day of contact and begs not to have to go. I tell him he needs to, and he blames me. It's heartbreaking. I feel so powerless and that I'm letting my son down.
After a long court case where I had always opposed unsupervised contact for my son due to my concerns about his dad's behaviour, he was then ordered to have unsupervised overnight stays with his dad every week. My personal concerns aside, this felt like such a big change for a 6-year-old to suddenly adapt to. His dad hadn't been in his life for several years. Then my son started to disclose every parent's worst nightmare. He spoke about his dad hurting him on one occasion, and said he and his dad shared a bedroom. Then he spoke about sexually inappropriate behaviour from his dad towards him. I can't describe the despair and horror I felt for my son and what was happening. This went back to a proof hearing where my son's worker from Women's Aid reported her concerns and noted my child's views, namely that he didn't like being alone with his dad. A social worker even said that contact should return to supervised. The sheriff listened to both sides. Then They made the decision that I had coached and manipulated my child to say these things. They said my son was lying. Worst of all, my child was ordered to continue to go for the overnight visits, alone and unprotected. No child should ever have to go through this. I don't know what we would have done without the support we had from Glasgow Women's Aid at the time.
The all too common perception by sheriffs of mothers as being dishonest about domestic abuse, manipulative of their children's views, and somehow simply malicious towards their ex-partners must change. This silences the views of children and transforms the hearing into one where the victim becomes the person on trial. This case study was a particularly concerning account of abuse that our organisation was involved in supporting a family with. It was one that actually really opened the eyes of workers to the realities of the sheriff court system, and that they simply don't at times appear to first and foremost consider the best interests of a child. This case study involved a primary school aged child whose father had been formally charged with sexually assaulting and raping the child's elder sisters over a prolonged period of time. He was also accused of domestic abuse against their mother, for which the family had had to flee the family home. While in Scotland a person should be considered innocent until proven guilty in a court of law, clearly the grave concern about this child's father should have been taken into account. If we consider the guidance in child protection previously discussed, it states that there only needs to be a likelihood of abuse having taken place for agencies to take action. We feel that an order of no contact would have been safer and more appropriate for this child until the criminal case had concluded, before a family court attempted to make any decision around risks or contact. Any informed professional could identify that there is an unimaginably high risk of physical and emotional harm to the child. In no civilised society should we see children ordered to spend time, supervised or not, with accused sexual offenders. This case is a clear example of how the rights of a parent have superseded the best interests and rights of the child. To further analyse the context of sheriff decision making, it's helpful to consider the evidential test that sheriffs have in relation to family court proceedings and how this compares to other evidential tests in the Scottish justice system. The criminal court system requires that the burden of proof is proved beyond reasonable doubt. This is a high bar that means evidence of crimes do not, unfortunately, always meet the test required. The main aspect of this is due to the need for corroboration, which is two independent pieces of evidence relating to the same event. The civil court system, which deals with family law and contact cases, on the other hand, doesn't require such a high test. The burden is set to the balance of probabilities, with the proving of the facts resting on the person who asserts it. There is also no need for corroborating evidence, which is helpful to victims of domestic abuse, given the often covert nature of abuse. The sheriff simply has to listen to both accounts and determine the version of events that they prefer and which appears more likely than not to have occurred. Given findings like those just shared, and indeed the abundance of research, evidence, policy and legislation that notes gender-based violence and its impact, most would argue that the family court should have no difficulty in believing victims of domestic abuse on the balance of probabilities. Informed individuals will know that we still live in an unequal society and that there is both national and international recognition of violence against women and children perpetrated predominantly by males. And yet, as we heard examples of in the case studies, mothers report that their children have been accused by the courts of lying and fabricating stories, or that their child's account has simply been disproved without real explanation. As a collective, we have to ask ourselves why family courts regularly determine that children would lie about abuse, and also question why sheriffs are even allowed to say this in relation to such serious matters. Mothers also report that they themselves have been accused of lying to the courts and of coaching their children around the subject of abuse, and then telling their child to lie and say that this happened to them. This is such a far reach when considering the sheriff's role to choose an account that seems the most likely to have occurred. Why do courts regularly still prefer to believe this unrealistic narrative that a mother would commit such a damaging, abusive and dishonest act to her child? Of course, perpetrators of abuse will deny their behaviour to avoid consequence. Surely no court of law would generally expect anything other than a denial of bad behaviour.
When I was younger, I had to go to court to give evidence against my dad because he'd been abusive. I would like to describe what it was like for me to go to court. My mum wasn't allowed to sit with me in the waiting room. They said this was because she might tell me what to say, but it would have made me feel safer to be with my mum. It wasn't my mum who was on trial, so I don't understand why she wasn't allowed to be with me. It was video evidence that I had to give, and I was really upset after it. I didn't want anyone else, I just wanted my mum, but I wasn't allowed to see her. When I was giving evidence, my dad's lawyer called me a liar when I wasn't lying. It made me feel really bad about myself. He shouldn't have been allowed to do that. They have to realise that it's a child they're talking to, and they can't just say what they want. They have to be sensitive. My brother and I had to go to court 5 times before it happened. Sometimes we were there until almost 5 o'clock before we were told it wouldn't happen. Then my brother was told he wasn't allowed to be in the courtroom when he wanted to be. He should have been given that choice. Nobody from the court ever spoke to us again about the court case. It felt like me and my brother didn't exist. My dad was found not guilty. Nobody from the court told me it had to be my mum. People in the court were very disrespectful towards my mum, especially my dad's lawyer. After the court case, my dad thought he could do whatever he wanted. He lived near my gran and he used to drive along beside me when I was walking. I stopped wanting to go out. I was really scared. We had to move house multiple times because of my dad. My dad threatened to kidnap me and my brother. I didn't want to talk to anyone about it because no one had listened to me at the court, and other people would call me a liar too.
It takes so much courage and often years spent in fear before victims of abuse verbalise their stories of pain in the hope that they might finally live more safely. Family courts simply have to do better in accepting that abuse against women and children is a prevalent issue, and it is far from being an unlikely account. This dangerous, uninformed viewpoint from family courts puts the lives of children at risk.
My dad took my mum to court to have contact with us after that. None of us wanted to see him ever again after what he did. The sheriff listened to me and what I wanted because I was older. They didn't listen to my younger brother. They said he was too young to have a view. He was 8 and he had to go see my dad alone, even although he didn't want to. The court forced him to. I noticed my brother lost a lot of weight after this. I think it was because he was anxious all of the time. Even now he has issues with eating and is smaller than people his age. It really affected his mental well-being. He was old enough to know that he was old enough to know what he did and didn't want, and the court should have listened to us and our mum about how it wasn't safe to see my dad.
After a court order regarding contact has been made, women who are unable to comply due to their fears for their child or because they are unable to force their child can be held in contempt of court, with penalties attached. Sheriffs may even threaten to change the residency of whom the child lives with, meaning that they could end up in the care of their father full-time, despite the grave concerns the woman has reported, and often entirely against the views of the child, who may be terrified to see the perpetrator for even a short period of time. Women have to make an unimaginable decision, choose between complying with an order that could put their child at risk, or have their child taken permanently from their care. Women have also reported that threats have been made to place their children in the care system if they don't force and facilitate contact with the child and their father. This could not possibly be described as a decision by the family court that has been made in the best interest of the child. Rather, placing a child into the care system for such limited reasons would be entirely irresponsible and a devastating outcome for any child. This, again, is an example of the insidious nature of patriarchal decision-making in family courts, that it's fully centred on the rights of the perpetrator at all costs, while the rights of the child are lost.
I would like to talk about my experiences of contact centres. I've been attending a contact centre with my younger sisters. They did not want contact with their dad, but were told they had to go every 2 weeks because of a court order. They would be upset and crying, and sometimes my mum had to really persuade them to go, even though they were very upset. Workers in contact centres need to be better trained in working with children and keeping them safe. Currently, workers try and encourage children to have contact when they don't want to. These workers should listen to the children and not put pressure on them. The workers did not respect my mum's views, wishes or concerns. Staff need training on how to communicate with mums and children, especially when there has been domestic abuse. Every family has a different story. Contact centre workers need to understand that story before they treat us like we're all the same. Contact centres are not welcoming places. The facilities are poor and children do not enjoy going there. Children should not have to be a certain age to say they do not want contact. When decisions are made, children should have the right to ask questions and appeal. I understand all of this because I've been through it, and it's important that you understand too and use your power to change things.
A common disposal for sheriffs in cases of concern is the use of contact centres. However, this is problematic in domestic abuse cases or cases where there is concern around any type of abuse. Supervised contact is a temporary measure which is intended to change to unsupervised in the community after a period of time. This does not adequately address the issue for children where perpetrators have behaved in a certain way only because of supervision. Domestic abuse and physical or sexual abuse of children does not tend to happen in front of witnesses in the first place, and so a supervised contact is not truly assessing or addressing the risk of repetition. Furthermore, and most importantly, the child is still highly unlikely to feel emotionally or physically safe being in the presence of the perpetrator, whether it is supervised or not. The consequences of further exposing children to an environment where they feel unsafe could have a long-term or even lifelong consequence on their development.
My children, who are nearly 10 and 7, have no faith in the system. Their father now has residency. They live in hope that one day they will be brave enough to speak up again. They speak to me, but they do not dare speak to anybody else. They know they will suffer the consequences if they talk again. They will stay silent until they know it is safe to talk again. I never once wanted to remove my ex-husband from our children's life. I only wanted to protect our children and keep them safe. I had 3 years with residency with my children after leaving my ex-husband. I hope in those 3 years and in the time we have together now, it's enough to teach them right from wrong. In my experience, as long as my ex-husband has a good solicitor, my children will not have rights. They will not have a voice that is heard in court. New laws are passed to protect children, but there's always going to be solicitors to twist what is being said.
It's important to note that there have also been some occasional good outcomes in relation to court-ordered contact for the children that we support. We genuinely hope to see more of this in the future and that it greatly increases. However, as the case studies highlight, a culture shift of the family court system is overdue. Until prejudice and stigma is addressed, it will continue to allow discrimination and the poor application of even good pieces of legislation. Children are vulnerable, and as such they require more protection than adults. The focus on the contact rights of dangerous perpetrators must end so that we are no longer failing children in Scotland. We note the appointment of a Domestic Abuse Commissioner in other parts of the UK and suggest that a similar post holder in Scotland would offer much needed scrutiny of the justice system and more reform. For example, no longer allowing sheriffs to be appointed to family cases unless they have had a practising law career specialising in this area. The cases of the nature described today clearly demonstrate that the decision maker requires an in-depth knowledge of domestic abuse and child protection. We are also delighted to offer further suggestions and observations about improvements to the justice system as set out by child survivors of domestic abuse, and also what Glasgow Women's Aid as an organisation have been doing to support this.